when we were putting together this presentation, we were talking about doing something on pipeline construction. I'm sure some of you may have heard of the Marcellus Shale. I'll talk to you about it later, what it is. And so we said, okay, Dave, why don't you come up with something, because you've been doing a fair amount of pipeline construction work. And I said, well, there is not a lot of case law out there, unfortunately. And as you can see, choice of law clauses, I mean, a very exciting part. That's probably why they put me up early. They hanging on for the P3, which I'm sure everybody wants to talk about later. So I have to talk about something. Choice of law clauses. So with regard to the pipeline construction, I've seen about 3 or 4 new cases that I've personally been handling with some of my colleagues. One is a local one, which started out as a mechanics lien claim down in Greene County and Wetzel County. There was 45 miles worth of pipeline that was installed. Lo and behold, the contractor was not happy with the amount of money that they were being paid, even though they bid it on a unit rate basis. They filed a claim for $24 million. They asserted a mechanics lien against a compressor station down there and didn't assert it against the rest of the pipeline. And so what they were saying is that, hey, we had a $24 million overrun on this project, but we're only going to lien this little square compressor station. And the reason they did it is because it's a lot easier to identify the property, the meets and bounds. And we objected to it. We said, listen, if you're going to lien for the pipeline work, you've got to lien every single parcel where the pipeline is located. And of course, they didn't want to do that, because that would have meant they would have had to go out and figure out, check deed after deed after deed. And they didn't want to do it. Very expensive, a lot of work. So we objected, and unfortunately, before the case was decided, the parties settled, which us lawyers like and don't like, because I thought it was an interesting legal question. And we never got it decided, so of course that didn't make it into our presentation. Luckily, there was a carve-out in the settlement agreement for warranty work. And I think the parties knew that at some point something was going to come up from a warranty standpoint, and what was happening is that there were a number of avalanches or slips with the pipeline. And what's a slip? Well, it just sounds like this little cave-in of some property. So I said, I'm going to go take a ride down and check this out. And let me tell you, my thighs have, they're still burning from this trip up and down these different slopes. If you've ever seen those fire trails on mountains, that's what the pipelines follow. And what's happening with some of these pipeline construction cases is a contractor is from Oklahoma or Texas. He's used to just going on this flat property and just laying mainline one after another. He's not necessarily ready for the up and down of our terrain, the weather and so forth. And so when he submits his bid, he's not taking into account what it's going to really cost. And then once he starts incurring all these huge costs, he's looking to make it up on the back end. So I guess and this is just common sense advice, but everybody's rushing through to get these contracts hammered home. I mean, you get a notice to bid, you get a notice to proceed, you get a notice to award, and then when you try to put together what the contract states, you have no idea. So my point is, you might want to take a little bit of time to make sure you know what's in the contract. It's common sense. It applies to every construction contract. Really crazy with that. So we never found out what happened with that. The warranty case is still going on. I have another case that was involving some pipeline down in West Virginia where the contractor actually liened the wrong property. And we objected to that, and the court actually granted our objection immediately, and the case went away. So again, when you're liening some property, make sure your counsel knows which property you're talking about. And the other one I wanted to talk about, and again, it didn't make it into any case law so far, but it's a case out in the Middle District involving some pipeline that was being laid. Parties entered into a contract, $90 million unit rate contract, and the contractor in his original bid had a weather contingency in his bid. According to the contractor, he was told to take the weather contingency out. He did take it out, and then he incurred all kind of weather-related costs after the fact, but there was nothing in the contract to protect him for the weather contingent work or the weather-affected work. He now has asserted a claim for $42 million. So that case is going to be interesting, trying to figure out who gets what. The contract says this is what you're going to get paid, but they're claiming that all kind of promises were made outside of the contract. Again, my point is, when you're putting together your contract, make sure that you fully understand the scope of work and the compensation, and even then, parties are going to fight when you're talking about $42 million. It's worth trying to get some of that money back. So that brings us to my presentation. I'd like to thank Marc Felezzola for doing more than just assisting, for actually doing all of the work with regard to the slides and the case law. So we're going to talk a little bit about choice of law clauses in contracts. A lot of times parties will include a clause in their contract that designates the laws of a particular state to govern the contract and any disputes that might arise. This is typically known as a choice of law clause. The enforceability of these clauses differs upon the type of contract in the state where the work called for is being performed. As many of you know, in Pennsylvania and New York have enacted statutes that render choice of law clauses unenforceable for construction contracts being performed within the states of Pennsylvania. So if you have a project in Pennsylvania and you state this, any disputes in this contract itself will be governed by the laws of Texas, those clauses are unenforceable, as many of you know. Unlike Pennsylvania and New York, though, West Virginia has no statute that renders unenforceable a choice of law clause. However, a recent decision by the Federal District Court for the Southern District of West Virginia has called this into question, the enforceability of choice of law clauses under West Virginia law. In Elk River Pipeline versus Equitable Gathering, LLC, the parties entered into a master construction services agreement, which I'm sure many of you have been asked to sign, making Elk River a shortlisted bidder for EQT. The master services agreement provided that the agreement must be construed according to and governed by the laws of the Commonwealth of Pennsylvania. The contractor, Elk River, subsequently bid on and was awarded a unit price work order for the construction of about 2.5 miles of pipeline in Logan County, West Virginia. After Elk River began its work, EQT, the owner, informed Elk River that its scope of work no longer included the portion of the pipeline that was easiest to construct. So apparently when Elk River put their bid together, they had about 1.5 miles of very simple work, $10 per linear foot, versus hard work up and down and so forth, $20 per linear foot. And at that point, EQT said, you don't have to do the easy work. So what did the contractor do? It sought an increase in its unit rate, saying that, hey, you took away the easy work, and as a result, our average unit cost needs to be increased accordingly. EQT took the position that the carrot section was never included in Elk River's scope of work, and they refused to grant a change order increasing its unit prices. The contract, the scope, when the bid was submitted, the bid actually had a bunch of quantities in it saying we're going to be installing, I think it was like 30,000 unit segments of the work. The actual purchase order that was entered into states that the scope of work is perform pipeline construction services as requested by an authorized rep of Equitable Gathering, unless the purchase order is otherwise terminated. So what in the world does that mean? Perform construction-related services. So that's my point. There is no quantities, there is no rate that's delineated in the contract, and of course, when something is changed, everybody's going to start arguing as to what that has meant. Litigation, of course, ensued, and during the course of the litigation, a motion for summary judgment was actually filed by both parties. And one of the issues that came up is which law should apply, Pennsylvania or West Virginia. EQT took the position that under the Master Construction Services Agreement, the Pennsylvania law applied. Elk River disagreed and said that West Virginia law applied, and they said that the Master Services Agreement did not apply here because Pennsylvania had absolutely no relationship with the project, which was in West Virginia. So what the court do, they cited a West Virginia law which states that a choice of law provision in a contract will not be given effect when the contract bears no substantial relationship with the jurisdiction where the parties have chosen to govern the agreement, or when the application of that law would offend West Virginia public policy, as if that can happen. The court then applied this standard to the facts of the case and found the fact that despite the fact that EQT was headquartered in Pennsylvania, the Master Services Agreement lacked a substantial relationship with Pennsylvania. What did the court analyze in coming up with its decision? All of the work was performed in West Virginia. Plaintiff Elk River was a West Virginia resident. EQT maintained a West Virginia office out of which all correspondence emanated. Elk River issued its invoices for the project out of an office in West Virginia. And what was interesting to me, and I don't know, this comes up from time to time, but neither party knew where the contract itself was executed. They couldn't come up with any evidence as to where it was executed. And it's important for jurisdictional purposes when you get a contract, if you can somehow say, hey, so-and-so executed it, and they executed it in this jurisdiction, but nobody could really figure out where it was executed, so the court took note of that. So, what do you take away from this? Following this decision, the enforceability of choice of law provisions in West Virginia is much less certain. I'd say that it's probably, they're not enforceable. So if you're entering into a construction contract down in West Virginia, you should be aware that this provision is likely unenforceable. How do you protect yourself? Well, of course, you perhaps put a separate venue selection clause in your contract saying, even if you said, for a project in Pennsylvania, if there's a dispute, we'll go to West Virginia. You can't really litigate in West Virginia, but what you could do is say, we want to have an arbitration. In this case, what EQT should have done is said, any disputes that arise must be arbitrated in Pennsylvania. Those are enforceable. The arbitrators in Pennsylvania then could apply West Virginia law. Probably your best bet. So that's really all that's out here on pipeline construction. I mean, we're starting to see stuff, as I mentioned. Happy to talk about what we're starting to see, but just from what is being recorded, this is about it.